Case number 119726 in the matter of David E. Herron II, respondent.
Good morning. Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I would request 5 minutes rebuttal.
5 minutes is granted.
Thank you. As the court is aware, this is an original action in attorney discipline. It arises from 2 complaints regarding Mr. Herron's representation of 2 criminal defendants. The allegations and the corresponding findings of rule violations involve improperly disclosing attorney-client confidential communications, lack of candor toward the court, conduct involving dishonesty, and conduct prejudicial to the administration of justice. Mr. Herron has filed exceptions, arguing that there is not clear and convincing evidence to support the rule violations, and he also takes exception to the discipline imposed. This time I'd like to just briefly go over the rule violations and the clear and convincing evidence that supports them, and preemptively maybe address some of the arguments Mr. Herron has raised in his brief. The first issue, like I said, involves Mr. Herron's representation of a criminal defendant with the initials of DJ. She was being charged with a drug offense, and part of her bond condition was that she would submit to urinalysis tests, or UAs as I'll call them from here on out. The misconduct arises from an incident that occurred on July 27th when they initially were supposed to be there for DJ's sentencing. At that time, Mr. Herron disclosed to a court services officer, actually 2 of them in the presence of a county attorney, but for purposes of this argument, we'll talk about one court service officer, Ms. Knapp. And at that time, according to Ms. Knapp's testimony and affidavit that she prepared right after the incident, Mr. Herron said that his client DJ was cheating on the UA tests, and when he was asked, "How do you know that?" he sort of shrugged. Then there was a conversation about, well, her husband smokes pot, so it can't be his urine, and Mr. Herron responded, well, it could be that she's having her children's urine placed in tiny little scope bottles and inserted inside her. Mr. Herron's testimony is that he did not, in fact, say that his client was cheating on the UAs. He just said that she knew how. And Mr. Herron also testified that his client had, in fact, said, I did not cheat on the UA. I'm not cheating on the UAs, but it would be easy to do this by inserting someone else's urine into your body. The panel found it didn't matter whether Mr. Herron told the CSO that my client is cheating or that she knows how, that either way it was a confidential communication that was disclosed to him during the course of that representation. The panel rejected Mr. Herron's arguments that basically there's, I think, several, but the 3 that are relevant here are that, first of all, it was that our complaint did not establish that his client, DJ, had expressly authorized him to disclose this information, and that there was no clear and convincing evidence that DJ expressly authorized him to disclose this. So I'd first say on the complaint, it's notice pleading. He was in notice that it was a violation of 1.6, but perhaps even more importantly, the respondent affirmatively represented twice during the hearing when expressly asked, are you planning on submitting evidence that this defendant, DJ, is going to testify that she told you to tell them she was cheating on the test? His answer, I'm going to present evidence that this was impliedly authorized, yes. She did not specifically say, go ahead and tell them I cheat, no. Later he was asked again, his response, she did not tell me go ahead and say this. I chose this as a strategy, that is correct. So based upon that, in and of itself, there's clear and convincing evidence that DJ did not expressly authorize him to disclose this information. The second thing he said is that it was impliedly authorized that he could disclose this information. And I think the gist of Mr. Herron's argument is that there was a clean drug test on May 5th. There was some circumstances that resulted in DJ being incarcerated from May 5th, I believe, till May 7th. And at that time on May 7th, she did another UA that was dirty. And she then confessed on that May 7th UA that she had used drugs on April 20th, and then I believe on May 3rd. I'm not exactly sure the dates, but sometime during that time frame. And Mr. Herron's argument then is, from that point on, his client was having to have these strip searches or these cavity searches, and she didn't like them. And so he was impliedly authorized to disclose to the CSO that she knew how to cheat them or was cheating on them, so she could get a blood test and not have to undergo these strip searches, cavity searches.
At the state's expense rather than her own.
Correct. The problem with this argument, there's several problems with it, but on a July 28th hearing that sort of occurred after this disclosure and after DJ had been exposed to a cavity search that she talks about on the record, she told the court, I'll give a UA. I mean, if she wanted a blood test, that would have been the opportunity to say that. But when they were talking about having the court order one, she said, I'll give a UA. Secondly, even if Mr. Herron reasonably believed that this disclosure was impliedly authorized, it kind of belies his whole argument, which comes later and towards candor, and I hopefully will explain this clearly. Mr. Herron says that after that May cheating incident, she was exposed to these cavity and strip searches. He also says that she repeatedly tested clean. So if you follow what he's saying and his truth, she's undergoing strip cavity searches, she's testing clean. So the question then becomes, when he is trying to get a blood test or stop the strip and cavity searches, why doesn't he just say, she's been testing clean, you've been doing these, please stop doing them, there's no need to do it. I guess the simple what I'm trying to say is there is no need to disclose her supposed allegations that she's cheating a UA test or knows how to, in light of his own factual representations. The third, and this is really what I think the panel focused on, is that implied authorizations under 1.6a are those authorizations that are to promote a client's interests, to help them, not harm them. Mr. Herron's later argument is that he was allowed to disclose under 1.6b to keep her from committing a crime, establishes why it wasn't an implied authorization. He's basically telling a CSO that his client either has committed a crime or is going to commit a crime or knows how to commit a crime. So such an implied authorization does not help his client, it hurts his client.
Remind me what that resolution of the 1.6b argument was.
So 1.6b, and meaning that he was permitted to disclose to keep her
Just what was the resolution of that?
by the court, or by the panel, I'm sorry.
Were there fact findings in that regard?
I did not see any fact findings on the hearing panel report. I would say it's a legal argument though, okay? And I'm going to tell you why it's a legal argument.
Well, that 1.6b uses the word reasonably believed.
Correct.
Doesn't have to be some factual foundation?
There are facts in the record. There are clearly facts in the record, and it's Mr. Herron's testimony. Mr. Herron's testimony says, my client never told me she had cheated on a UA or that she was going to cheat on a UA. Based upon his own representations, that defense is not legally supported then. You have to have a reasonable suspicion that your client is going to, this issue was addressed at the hearing, but I will concede I did not see it addressed in the final hearing report.
Is it, and that you're just saying that's not a problem for us?
I don't think it requires you to decide any issues of fact that aren't in the record. I think based upon even Mr. Herron's submissions in his brief, you can decide that issue. Okay, so the next issue is 3.3a. A lawyer shall not knowingly make a false statement of fact to the tribunal. Here, the court found that Mr. Herron's July 28th statement to the court, she's not on drugs, for 16 weeks she has tested clean, she's tested clean again, that was a false statement of fact to the tribunal. The easiest one to address is the 16 weeks. It's clear that it wasn't 16 weeks. I'm not good at math, but from May 17th to July 28th, I think is 10 weeks. So 16 weeks is not 10 weeks is not 16 weeks. The other issue is when he said to the court she's not on drugs. In the statements that Mr. Herron had made previously to the court services officer, that she believed, and she put in the affidavit that he said that she's still using. It's sort of disingenuous to be reporting that my client knows how to cheat, and then the next day reporting to the court she's on drugs. I mean, he could have just said she's
Not
tested.
on drugs.
I'm sorry, she's not on drugs, yes. He could have just said she's tested clean since May 17th, but to affirmatively state that she's not on drugs was the false statement of fact. And the hearing panel lays out the other findings for that too. I want to go really quickly to the 3.3 findings in regard to RB. And this involves the client. This is the second criminal case. And in that case, RB had showed up late for a sentencing. A bench warrant is issued for his arrest. He shows up later at Mr. Herron's office, and there's some efforts to try to talk to Mr. Cruz. Mr. Cruz does not talk to them. Again, the hearing panel report lays out very clearly the findings of fact to show there's a 3.3A violation in an ex parte hearing that's had before the court where Mr. Herron says, "I'll represent to you, Judge, I hustled on over to Division 2 where I thought Mr. Cruz might be, or Courtroom 2. He had already returned to his office. He was there. He declined to come here today. If you can get me on the phone, fine." The hearing panel found the best evidence was the note that Mr. Herron had given to Mr. Cruz. There's nothing in the note that says, "I'm going to court to surrender this client." It said, "I'm going to surrender the client, and if you have an objection to resetting," meaning the sentencing, "call." So they found that that was a dishonest statement. I see I'm out of time. I can finish up and rebuttal unless you have some questions.
My question is, at some point, either now or in your rebuttal, would you tell us what your proposal is today for discipline?
I'd be happy to share it right now if you
That'd be fine.
would permit me that. The hearing panel found suspension was appropriate and a 30-day suspension. At the hearing, this office recommended disbarment, relying upon the standards that are cited again in the brief. I will concede before you today that the hearing panel made a finding that his conduct was knowing and not intentional. The standards for disbarment require intentional misconduct. We did not file exceptions to the hearing panel's finding, and there's been some discussions since this brief was filed about that issue. So, cut to the chase. My recommendation today, and I'll talk more about it in my rebuttal, is that this is serious misconduct and that it does warrant suspension. And so I am asking today before this court an indefinite suspension. And I'll elaborate more why.
All right.
Thank you.
Any questions of counsel?
I've got one. One of the things that was bouncing around in this case was the respondent's vigorous defense of the allegations against, the thing we always look for, which is remorse and that kind of thing. How do you balance those two pressures in terms of your office's prosecution of these cases?
I think that's a great question because it's
Good.
because it's kind of tricky, because a respondent is entitled to raise a defense. They are entitled to file exceptions. So it's not the fact that they've raised a defense or the fact that they filed exceptions. I think what we have to look at is the substance of that defense, and it appears to me that there's one thing between, first of all, I'll just say in this particular case, the hearing panel found he didn't acknowledge the wrongfulness, but they weren't holding it against him. They weren't weighing that, so I think that's important to note. I think it comes into play when we're trying to determine the appropriate sanction in this particular case, because when you look at the nature, the substance of his defense, it shows an absolute lack of understanding about duties that are owed to clients and duties of candor toward the court, and that's troublesome. Am I going way beyond?
Well, you're answering his question so far.
Okay, so for example, one of Mr. Herron's arguments is that I didn't disclose anything that was protected under 1.6 because DJ had already admitted she had cheated, and they knew she cheated. Well, first, I'm not sure that DJ admitted she cheated by having the UA on May 7th, but that's akin to saying the state's evidence against my client is overwhelming. The state knows my client committed this murder, so therefore it's okay for me to tell the state my client confessed to that murder and how they did it. And that's troublesome if he truly thinks that's okay and he's representing clients. So I think I've gone far afield from your question. I think that we can look at the substance of a defense and see whether or not what's claimed in that is an aggravating or a mitigating factor.
All right, any further questions? Thank you, counsel.
Good morning, may it please the court. I'm David Herron, the respondent pro se. I met DJ, my client, for the very first time right before the criminal call docket on May 5th of 2015. And as Magistrate Zimmerman began to convene the docket, Judge sent DJ, as well as several other defendants, over to the Geary Court Services office, which is just across the courthouse square. Geary Court Services did administer a UA upon my client. She tested free and clean, negative for any drug tested. However, immediately after she delivered this clean UA, she was arrested and taken straight to jail. The district court had issued a warrant because of the delay DJ encountered in getting across the courthouse square. It was about 40 minutes, evidently. And so DJ was taken straight to jail after giving a clean urine sample. Geary Court Services officers suspected a cheat. They suspected something was afoul. They demanded that DJ be retested and even visited her in jail, requesting that she be retested. However, both of the cases were continued to the morning docket on Thursday. I appeared with DJ while she was in custody on Thursday. Geary Court Services officers persuaded the same jailhouse accusations against my client to Magistrate Zimmerman. Judge Zimmerman agreed that something was awry with that May 5th test, so he ordered a retest before DJ would be allowed to leave the jail. The result of that retest confirmed that the Geary Court Services suspicion of cheating was absolutely dead accurate. My client then...
Now, how can you say that? I mean, it was a dirty UA on May 7th, but how does that establish in and of itself that there was cheating rather than testing failure or some other... So, I mean, that didn't establish beyond a reasonable doubt that she cheated.
Beyond a reasonable doubt, possibly not. However, remember that Magistrate Zimmerman sent several other folks over there. There was no other complaints about the machine not working. Several of my clients were tested. DJ was the only one that had this sort of anomaly. So that is a good question. They strongly suspected that DJ had cheated.
Well, and my point is the fact that we have circumstances that strongly suggest that your client may have worked the system, may have cheated on the test. I don't understand how that then, because it's strongly suggested by the circumstances, that gives you carte blanche to reveal client confidentialities. That concerns me a whole bunch.
And it should. It does not. It does not give carte blanche, but pragmatism is certainly in order. As when DJ knew that she was pretty much caught red-handed, she then executed a written statement. In that written statement, DJ did confess, I used drugs in advance of that May 5th test. The May 7th test is the accurate one because I used meth, opiates, and THC on May 3rd, May 4th, and April 20th, respectively.
And did that confession include a concession or an acknowledgement or a specific statement that she cheated on the May 5th test?
Specifically, no.
Okay.
It did not. But the facts spoke for themselves. All of those that were present and involved in that situation knew pretty well what was going on. DJ tests clean, is arrested, tests dirty. DJ fesses up. She knows she's been cooked.
You say she fesses up. You or her counsel? Did you assist her in this statement? And I know we're getting into the nuts and bolts here, but I don't know. How did that statement come about?
I'm a little offended that my client was interviewed without me being there. She was confronted in the jail by Geary Court Services officers who put the statement in front of her and says, you need to tell us what happened. Is this May 7th test accurate? When confronted with the May 7th and the May 5th test juxtaposed, my client came clean. She knew that she'd been had. And she stated that in that May 7th report, which is in the record and you see it. I made a judgment that it was a no-brainer that she cheated. That's a judgment that I made as her lawyer. I'm trying to represent her the best I can. I need to be candid and I need to be open. I made the judgment to be transparent and open because the facts in this case indicated this was not a confidence. This was something they knew and they gloated about. Geary Court Services officers actually just gloated about. They knew they had her dead in the water.
Counsel, the confidence is distinct from privilege.
Yes.
You understand that, right?
Yes.
And a confidence can be something that your client doesn't want revealed regardless of how many people already know it, can't it be?
That is true.
So why isn't this a revealing of client confidence?
There is no
Even if everybody kind of knew what was going on.
This was a negotiation tactic. First of all, that's your official comment 1, it's official comment 6, which is cited in my briefs. In negotiation, I'm allowed to make reference to matters that can't really be reasonably disputed. I made that judgment that Geary Court Services officers agree that they caught her cheating. Geary Court Services each time.
No, finish
You were
it.
about, okay, before
Yeah,
Justice
I
Bynum.
want to hear the rest of that. Yeah.
Each report, Justices, includes a choice for drug testing. The choices are blood, urine, and saliva. These choices are presented on the reports that Geary Court Services could use any of those. My negotiation tactic was clear. I knew that if I asked for a blood test, my client would have to pay for it. BIDS has taught me we don't have the money to front. Our client has nothing. If we could bait Geary Court Services into making the request from their end, then at least the county would advance the costs and we might be assessed that at a later time. So this was a negotiation tactic. Meet Geary Court Services with something that we agree on and use that to my client's advantage. I know that she has the ability to dupe these tests, and so do you. Why then are we resulting to these strip searches and UAs when there's an easier way to get this done for my client? Now that is something that my client did share with me. She was deeply troubled and deeply offended by the strip searches that went on. As soon as she got caught cheating, or Geary Court Services, I should say, thought they caught DJ cheating, they implemented these cavity searches, and she described them for me. Squat and cough, lay down on your back and pull your knees up to your chest. It sounded humiliating and she was in tears. So I acted on behalf of my client, used my discretion in a negotiation to try to get those strip searches to stop because they would not just let her do a UA without strip searching her once they caught her like they think they did. DJ did.
So what triggered the strip searches was the confession on May 7th.
Yes, that's when they started, Judge.
Why does she say that?
She just started them the day before the July 28 hearing then. Isn't that what she says? They just started yesterday, or they just started?
That's a good question, because that, Justice Beyer, I think I know the comment you're talking about. First of all, my client was sobbing and in tears at this hearing. She did say, never before have I had to do this.
Right.
What she meant, and what we all interpreted her to mean, is she was a frequent flyer in the system. She'd been giving UAs hundreds of times, but up until this case, and since that incident, she had not.
Okay.
The transcript is also reconciled by one of the Geary Court Services officers pointing out, we gave her another strip search this morning. that indicates that this wasn't the first. Okay, so she had been cavity searched over and over and over again. And let's also use some common sense, justices of the Supreme Court. With that incident in May 5th and May 7th, do you really think they're going to delay until July to take any remedial action? Of course not. I, as their lawyer, know they're not. So when my client is complaining to me about these invasive searches, I knew she was telling the truth because it matched up with common sense.
Well, the common sense I'm having a problem with is the logic here. You're saying that she tested clean May 5th and then tested dirty May 7th. That in and of itself were circumstances that would indicate that she was cheating on the test. And then you say that wasn't enough. That evidence of cheating wasn't enough to get blood tests. You had to tell them that she knew how to cheat in order to get blood tests. And I don't understand. If the circumstances were such that it established that she was cheating, why wasn't that all you needed to pursue blood tests? Why did you need to reveal client confidentialities for that negotiation tactic?
Looking back, Judge, I don't know that I would have done it any differently, but it truly was an option. You're correct in pointing out that was an option available to me. Looking back, of course, I wouldn't be standing here had I just not even recommended that. But clearly, the client's indigency and inability to pay the $150 for the lab fee and for the blood draw at the hospital. My client would have probably taken a week to come up with the money, and she didn't want to sit in jail for a week. All right, so yes, Geary Court Services does give the option of testing in an alternate means, provided you pay for it. However, if I could dupe or get Geary Court Services to be the ones making the motion or recommendation, then we skin that cat without my client having to sit there and come up with the money. I did file a departure. Are we finished with that line of inquiry? Because yes, Justice Johnson, I go over this time and time again. I made that judgment. It was a judgment call based on what I believe to be in the best interest of my client. If you think it was a wrong judgment, justices, then consider this in mitigation. Did I do it for a selfish motive or an improper one? No, I made a judgment what I thought was in the best interest of my client at the time. I filed a departure motion. Primarily, my departure motion relied on the fact that, yes, she tested dirty in May, but ever since that one dirty test that followed the cheating incident, my client stayed clean. She did confide in me. Yes, she did confide in me that she's taken hundreds of UAs for these folks before. Never before this incident did they ever strip search her. So it was easy for a woman back then to just secret a vial inside of her, but now it's not. This cheating incident profoundly impacted my client because she realized the best way to pass a drug test is the good old-fashioned way. Let's just stop using drugs, and she did. She got clean, and she stayed clean for quite a while. On July 20, and also my departure motion attached the forensic evaluation report of Pawnee Mental Health Services. On July 27th, I appeared in court fully expecting to argue my departure motion. I was going to argue how long she was clean. I was going to argue that her jittery behaviors could be due to what's called the hypomanic episode within the bipolar diagnosis, as pointed out within the Pawnee Mental Health. I didn't get the chance. DJ was late. She storms into the courtroom, really, truly making a ton of noise and attracting a lot of attention to herself. Her husband and two children did the best they could to calm her, but it was no use. When Judge Hornbaker called our case up to the podium, he saw that she appeared quite restless, and he suspected she was under the influence at her own sentencing, so he required DJ to be taken into custody and drug tested because she appeared under the influence. She was taken to jail, she was tested, she tested clean. So her appearance was deceiving. She really wasn't using. Then, I'm called in the next day. On July 28th, I received word that DJ tested clean, come to courtroom 3, so I hustled over to courtroom 3, fully expecting to argue my departure motion that I wanted to argue the prior day. Judge suspected she was using drugs. She really wasn't because she tested clean. She tested clean. Again, by the way, Tony Cruz, the prosecutor, argued. He pointed out that the cheating incident of early in May, or that incident, whatever you want to call it, the suspicious one, is grounds or cause to make her retest again, just like she retested back in May. This time, however, DJ retested and retested clean. In between a clean test before and a clean test after, I argue my client is clean, and I end up having to defend a 3.3. I'm asking that you toss that one, okay?
Counsel, you're about out of time. At some point, will you tell us what you'd like for us to do?
Yes. Can I address the RB matter first, too, or do I even have time to, should I skip that?
Why don't you tell us what you'd like for us to do?
What I'd like you to do is remand this back, saying that I would like you to find, under the standards, 4.24 with regard to a 1.6a violation, the general for a negligent or a wrongful judgment in a release of client information is an admonition. I'm asking for no public discipline, and yes, an admonition could be released to the public if somebody wants it. What I'd really like is a private opinion, or I'd also like you to find in my favor. There was a troubling, close issue, but remember the burden of proof. Justice Johnson pointed out that there were two judgments I could have made, and it's a close call. Close calls are not clear and convincing evidence, justices, especially when my livelihood is on the line here. And I'm also asking to point out both of my clients got excellent representation. They got great results. RB got his sentencing put back on the docket very quickly, so there was no prejudice to the administration of justice or my client or the state in my representation of RB. And in this case, my client, if I adopted a strategy that seemed questionable, hindsight's 20/20. The strategy might have been weird, but it worked because my client received a grant of probation. So what I'm asking you to do is, because 1.6 requires the disciplinary administrator, not me, the disciplinary administrator to establish that DJ forbade this disclosure and they had no evidence of it, I'm asking that you send it back saying that you failed the threshold issue. I'm also, if indeed there was sufficient evidence, you know where my heart was and you know what I meant. I didn't mean to hurt this lady. I had her best interests in mind, so if I made a mistake in judgment, I sincerely apologize. And believe me, this has been quite a stressful ordeal for me. I've learned a lot. I lost my job that I loved. I moved out to central Kansas away from my kids in order to take this job, and I still loved it. And I really just wanted it back. I really love being a criminal defense lawyer, and believe me, the public and future accused, especially indigent clients, will have a good advocate in me.
What are you currently doing?
I work for, I do a lot of collections work, a lot of civil work. I also am,
You're in a private practice?
Yes.
Okay, you have your
I'm in
own?
Overland Park.
Okay.
Okay. A lot of criminal stuff still. I am also licensed in Missouri. The BIDS group took me off of their appointments list, but I still do quite a bit of indigent work in Johnson County, as well as the state of Missouri. I do their public defender conflicts.
Can you take about 60 seconds and address the issue about candor toward the tribunal?
With regard to which?
Tony Cruz, that issue.
Tony Cruz was on both cases, Justice. Do you mean with regard to RB?
When you went to his office.
Yes. I did go to, first of all, when my client showed up, I knew I needed to do two things. A, assess the availability of the judge. Can she even hear us and take it up? And if so, then get Tony Cruz over to the courtroom. I first verified that Judge Segarra was able to hear us if we can get to courtroom 4 in 20 minutes. All right, so I was in a hurry. I looked all over for Tony, and I did go to his office. I'm with my client, RB, and I do tell Julie Rose, it's urgent. RB just missed his sentencing, but Judge Segarra can take it up in 20 minutes. Can you get Tony and tell him to go back to courtroom 4? I got a blank stare from this gal. I did. It was clear that this young, I think she might have been in high school, didn't understand what I was saying, but she did disappear and talk to Tony. Because of the way she was standing, I didn't hear her, but I could clearly hear Tony saying, tell Heron to go away or have Heron call me. He can't just show up unannounced. So I did hear Tony Cruz say, tell him to go away and just have him call. I then wrote a note because I don't think it was clear that Tony really understood me. He went back in with the note, and once again I heard Tony say, just have him call, I'm busy. A Rule 3.3 violation, Justices, requires the disciplinary administrator to show that I knew exactly what Tony Cruz would have done and I lied about it. In fact, Tony Cruz didn't tell me directly anything. All I did was talk with his receptionist, and the receptionist says he's not leaving the office. He's staying in his office. Even though I said we're going back to court, he said with his body language that I'm not leaving the office, and he also said through his receptionist, I'm staying in the office.
Did your note actually contain the word court?
I said
Then it said
chambers.
you surrendered. Well, no, it's two different things. You said I'm surrendering RB, right? And then it said call Van Chambers or something like that, right?
Yes, it did.
Okay.
Call Van.
So your note wasn't abundantly clear about exactly what was going on. It was subject to interpretation. You'd agree with that?
Exactly.
Okay.
And it was more than 20 minutes. I thought I was in a huge hurry, so that's why I wrote the note so scrawled and hurriedly. I suspected that Julie Rose, the receptionist, was not being very clear with exactly what I was saying. I don't think he would, so that's why I made it very clear. I'm going back to courtroom 4 like right now, because Judge Segar is going to do a default divorce, and those only take like 5 minutes, so please, hustle up. And so I wrote it very quickly, Justice Beyer, after, because she went back and forth about twice.
But
The first-
what was there to indicate? Now the court had already ordered. Now I know you argue that there wasn't a default order issued, or a warrant issued, bench warrant issued, but the court had ordered that. Do you agree with that?
Yes, she
And
notated.
so you'd been to court, you had a court order, and basically what you're wanting to do is rescind that order, correct?
I didn't ask for that, no. I knew that if I presented my client to the judge, she could have him jailed right on the spot. That was one of the options available to her. All I did was present Mr. Bodwin and hope that the judge says, why go to jail for 3 days? But I never did ask to rescind the warrant. The judge did that sua sponte. I presented my client. I let the judge know I did my best to notify Tony Cruz. I invited him to court and he declined the invitation. And I know that now. What I thought in good faith, and I'm representing to you, I was a new public defender. I did not know Tony Cruz very well. And when I hear him holler from his office, have him call me, and I could hear that clearly, what I thought he was telling me was, I'm not going back to court with you, but just patch me in by the phone. And that's when I wrote the note. Knowing full well that he's not going to be there in person, the best I could do is just surrender my client and see what the judge does. Surrender my client and then reset it. And if my client had to sit in jail pending the new date, so be it. I did explain that to RB, my client, and it was a risk that he wanted to take. I did good for my client, I got a good result, and I did nothing unfair to Mr. Cruz. Only after the fact did I find out that when he said just have him call me, what he was trying to do is just shoo me out of his office and say, I can't see you, just call me on the phone or email me later. At least that's what he said. But truth be told, the panel found that I never said I'm going back to court. Let's apply some common sense. That's the sole reason I showed up in the office, was to get him to come back to court. Does the panel really believe that I had one of those brain spasms and I went and presented myself and then forgot the reason I was there? That makes very little sense, ladies and gentlemen of the Supreme Court, so I'm asking that you reverse that finding. You do find that I invited Tony Cruz specifically to come back to courtroom 4. I even left him a note asking him.
We understand your position
Good.
on that. All right, thank you, counsel.
Thank you for your time, Justices.
I would encourage the panel to look at the notes, see what it says. This is what Mr. Heron said before the court. I'll also represent to you, Judge, I hustled on over to Division 2. He was there. He declined to come here today, saying, if you can get me on the phone, fine. The note does not say to Mr. Cruz, I'm going back to the judge to get the bench warrant recalled. Mr. Heron testified at the hearing that's what he wanted to do. He never actually had to explicitly ask the court that when he appeared in front of the court, but that's what he wanted to do. More importantly, to 3.3a, we didn't address the 3.3d. I mean, this is an ex parte hearing before the court or a meeting, and it talks about you need to inform the tribunal of all material facts. Here, Mr. Heron never advised that he didn't specifically talk to Mr. Cruz. He did not tell the court that he didn't know for sure whether Mr. Cruz would object to the recall of the bench warrant, even when the court sua sponte raised that themselves. That's a violation of 3.3d. And it's fitting with what the hearing panel said on page 31 of their decision. The respondent's statement is a good example of one of the respondent's main difficulties. Rather than being accurate, clear, and complete, the respondent only provides a portion of information. Candor toward the tribunal is so very important. And then let's get to the journal entry that he drafted. And in that journal entry, it says that he personally informed the prosecution that RB intended to surrender himself to the court and request that the newly issued warrant be recalled. That is a false statement. And Mr. Heron's defense, one of his defenses to that, is indicative of why an indefinite suspension is appropriate in this case. One of his defenses to that is the court signed it, so it's a finding, and so therefore it's true. That baffles me. And then the next thing is that there's been no evidence presented that I actually filed it. Well, his testimony in the hearing was I dropped the journal entry off, I believe, before I left town that week. There's an email to Mr. Cruz where he says I'm going to drop it off at the court. We have some serious issues, I think, in this case of honesty, and that is a problem. And the reason why I'm asking for indefinite suspension today is that a reinstatement hearing, I think, is absolutely necessary. There is a difference between defending your conduct, but I think ultimately we have to protect the public. And part of that is to establish that Mr. Heron can at some point in time realize the problem with disclosing attorney-client confidential communications, the steps that you should take before you disclose those, and then the absolute duty to be honest and fully forthright and candid and honest before a tribunal.
Can I ask a couple questions about the confidential disclosures?
Yes.
I'm having a little difficulty parsing out exactly what was the confidential information that is alleged and the panel found to have been disclosed.
Mr. Heron's testimony, so we'll just go on that, is that he is having a meeting with his client, DJ, and he's telling her, I'm really happy that you've been doing so well. And she tells him during the course of their meeting, during the course of their representation, that it would be very easy to cheat on these tests, that you could take urine and insert them into your body in order to cheat the tests. Amber Knapp's testimony is that Mr. Heron said that his client told him she was cheating on the tests. I think the panel found either communication is something that's protected under the very broad umbrella of 1.6.
So, when you said he testified, you're talking about his testimony, respondent's testimony in front of the hearing panel?
Correct.
As to what his client told him?
Correct. And that he also disclosed that to the CSO. Not that she
knew how.
Right.
That she knew how, not that she did. He admits he told the CSO.
Correct.
And there is evidence in the record that supports the predicate finding that she actually told him that. Did she testify that she told him that?
You know what? No. And that raises a fascinating question.
Right.
Whether...
Like, could he essentially lie in the course of negotiations with the state?
So I think your question is
I'm just
it
trying to figure out...
possible that DJ never told him that
Correct.
information?
That's what I'm
he
asking.
Made it up.
And that he didn't actually disclose any confidential information because it didn't happen. He was trying to obtain a benefit.
I guess
for his
that's a
client.
possibility. Mr. Heron has never made that allegation.
The only evidence in the record is him saying she did say it to him.
Correct.
There's
And
no-
that he
That's
disclosed it.
hearsay, yeah.
And the panel did not make that predicate fact finding, that the information was actually relayed to him by his client.
I think they made it based upon Mr. Heron's admission.
But can you point to me where they made that finding in the panel report?
Well, I'm guessing they didn't by your question.
Well, no, I don't mean that as a gotcha, because honestly,
Yeah,
you
I
know more
think-
about it than I do. Maybe they did make that
Probably
finding.
in the recitation of facts, so are you asking, did the panel make a determination that we find it to be true
Correct.
that DJ disclosed this information to
Right.
Mr. Heron? I don't know. I believe they relied upon Mr. Heron's allegation.
Well, it's one of the problems, I guess, this is a bigger question, I sometimes have with these panel reports, that what purport to be findings of fact are really just cut and paste from the record. Like, so-and-so testified this, so-and-so testified that.
I understand.
That makes it hard
raises
for
a
us to
whole
know
other- right.
what are the findings of fact.
I think, and obviously Mr. Heron can't get back up here, but I believe if you look at his briefs and his testimony in there, it'd almost be like he probably would be willing to stipulate to the fact, I assume, unless he wants to change his story, that his client disclosed to him.
Okay, thank you.
Any further questions? All right,
No.
all right. Thank you, counsel.
Thank you.
We thank both of you for your arguments this morning and this afternoon. The court will take this matter under advisement. That